On March 22, 1972, the United States Senate had officially approved the Equal Rights Amendment, a constitutional amendment intended to remove all legal distinctions between men and women. In the next 2 years, 35 states had approved it in their own state legislatures, and the amendment had received considerable bipartisan support, earning the endorsements of Presidents Nixon, Ford, and Carter. It was all but assumed the amendment would be ratified and make it into the Constitution. Well, wait a second then, why don't we learn about the Equal Rights Amendment in class or hear it in passing? Well, for better or for worse, not every single amendment proposed makes it into the Constitution. So let's find out the story behind the Equal Rights Amendment, and what exactly is it, the history behind it, and what exactly comes next for it. So, what exactly is the Equal Rights Amendment, or ERA? It's quite simple. Section 1 of the ERA states the following: equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. The ultimate goal is to remove all legal distinctions between men and women. The history of the ERA began about right after the ratification of the 19th Amendment, which granted women the right to vote. That does leave a lot of questions unanswered, though. Why is this necessary? What's the other side saying? And perhaps the most curious question of all: what exactly happened to it? Let's answer the question of why it might be necessary to have an amendment like this in the first place. Yale Law Journal argues that our current legal structure discriminates against women by creating a separate legal status. This is accomplished through legislative acts that either grant special protections or free from certain responsibilities. It's fair to say that almost all of these acts stem from a good faith effort to advance the interest of women, but in the end, the article concludes that these attempts only serve to lower the position of women. One of the earliest examples of a separate status being established is Mueller v. Oregon, in which the Supreme Court upheld that women could be held to different labor standards due to state interest in protecting women's health. It goes without saying that women's citizens' rights are upheld within the 14th Amendment, but women have rarely succeeded in making claims pressing these rights. Activists believe that the ERA could solve this issue by setting the record straight. Sex discrimination is illegal. One of the strongest arguments presented is the idea of strict scrutiny within the court system. If a law were to violate a fundamental right such as the 14th Amendment or free speech, the court would apply the highest standard of review, otherwise known as strict scrutiny. State-level courts with an equal right law in place have ruled more often in favor of the plaintiff. Modern supporters claim that the ERA would protect reproductive rights from being infringed upon by states, and that special protections offered in the past are no longer relevant with the advent of the Civil Rights Act and the Equal Pay Act. On the flip side of the coin, though, opponents, including some feminist groups and labor unions, feel that the ERA would create harmful changes to society and women. The ERA, for most of its existence, has been fraught with controversy. If we jump back to the very beginnings of the ERA in the early 20th century, we can see that it divided many progressive-era feminists. Mueller v. Oregon was hailed as a victory for women's rights by reformers like Florence Kelley, a trailblazer in social reform. When the leader of the National Women's Party, Alice Paul, declared the group's ultimate goal to pass the ERA, Kelley pushed against this, even leading efforts to oppose equal rights. Black leaders like Mary Church Terrell felt that the group was ignoring the struggles of women of color and to work to protect their right to vote for them. The first text of the ERA entered Congress in March of 1923, which was written by Alice Paul and Crystal Eastman, both prominent figures in early feminism. However, the issues that Kelley and Terrell brought up were major players in the failure of the early ERA. It did not properly address the issues of working-class women and women of color. Criticism in the ERA in the 70s and 80s was more conservative and Christian-leaning, with the Stop ERA movement being built on the ideas of traditional gender roles. Opponents argued that the ERA adoption would require women, among other things, to sign up for the draft, decriminalize rape, allow for same-sex marriages, give men permission not to support the families, and require Americans to use unisex toilets. With the modern resurgence of the ERA, the criticism remains the same. The Eagle Forum and the Heritage Foundation's two groups associated with the Stop ERA movement have largely remained steadfast in their criticism of the ERA. So now that we understand the social thoughts on the amendment, what actually happened to it? The ERA was first introduced to Congress in 1923, but largely failed due to the opposition between feminist groups. Throughout the 40s and 50s, the amendment remained largely dead, with most New Dealers actually opposing the ERA, most notably Eleanor Roosevelt, due to the labor protections offered that the ERA would kill. The early 60s were not kind to the ERA as well. A proposal at the Democratic National Convention in 1960 failed big when groups like the ACLU, the American Federation for Labor, and many more opposed the passage of the ERA. John F. Kennedy supported the ERA as a presidential candidate, but his administration did little to support it. Esther Peterson, the highest-ranking woman in Kennedy's cabinet, publicly opposed the amendment, feeling specific issues should be dealt with specific acts. By the late 60s, though, the movement was gaining traction largely due to the frustration over the lack of enforcement of equal opportunity labor laws and the new networks of women's rights commissions formed by President Kennedy. The National Organization for Women was founded in 1966, and at the urging of Alice Paul in 1967, and yes, that is the same Alice Paul that wrote the original ERA, the group endorsed the passage of the Equal Rights Amendment. By the end of the 60s, the group and many others had gained significant political and lobbying power for the ERA. The 70s was groundbreaking for the ERA. A wide coalition of women from all backgrounds formed to support the ERA nationwide. The Senate passed it on March 22, 1972, and by 1977 the amendment received 35 of the necessary 38 state ratifications. The amendment had considerable bipartisan support, with President Nixon, President Ford, and President Carter all lending their support to the cause. However, supporters still felt concerned the amendment would not receive the necessary count of states for the ratification by the original deadline, March 22, 1979. The deadline for the ERA was extended to June 30, 1982 by congressional action and by President Carter signing the bill into law. The extension itself was highly controversial. Legal experts were divided as to whether Congress could actually extend a deadline for states to act on a federal constitutional amendment. Things were beginning to slow down for the ERA movement, but a counter voice quickly dismantled most of the support for the ERA in society. The Stop ERA movement, led by Phyllis Schlafly. The Stop ERA movement was founded to, stop the ERA. It argued that the ERA would dismantle laws created to protect women and strip them of protections and privileges. It was led by prominent anti-feminist Phyllis Schlafly, known for her adamant social conservatism and opposition to the modern feminist movement. Stop ERA included people from a wide variety of groups, but Schlafly otherwise handpicked state directors to steer initiatives forward. The group worked with conservative Christian groups and Schlafly's own conservative group, the Eagle Forum, to provide logistical support such as meeting spaces and networking with legislatures. Schlafly felt that the ERA would damage families and destroy the role of the homemaker, amongst other beliefs. She also felt that the ERA would eliminate Social Security benefits for widows and homemakers, feeling that women should not be in the paid workforce at all, but instead should be earning benefits to raise families. Regardless of the validity of the claims of the Stop ERA movement, it ended up being highly successful in changing the mood of the country. When Schlafly started her campaign in 1972, public polls showed wide support for the amendment, and 30 states had ratified the amendment by 1973. However, that year began the slow trickle of states ratifying the amendment, and public opinion had drastically dropped. Between 1973 and 1978, 4 states even voted to rescind their previous support for the ERA. After years of support for the ERA, the Republican Party dropped support for the ERA from their 1980 platform. Political scientist James Mainbridge stated that she felt the draft issue was the single most powerful argument used to defeat the ERA. While other conservative groups contributed to the failure of the ERA in the 80s, the Stop ERA movement was perhaps the biggest contributor to the failure. The biggest question still remains, though. What happens next for the ERA? After the failure of the ERA in the late 70s, the ERA for the most part only served to collect dust in the congressional archives. But with the forthwith feminist movement emerging in the Me Too movement, there has been a revived interest in the ERA. Supporters argue now that the gender protections are no longer relevant to the cause of the ERA. After all, women now serve in military combat roles voluntarily, and as of March 2020, the National Commission for Military, National, and Public Service recommends that women be eligible for the draft. Supporters argue now that the ERA will protect reproductive rights, as many states continue to challenge those abortion rights. The ERA aims to prevent sex discrimination, and unfair reproductive treatment could be included within the ERA. The most common argument is that the ERA is overdue to fully protect equal rights. While the Civil Rights Act and the Equal Pay Act reinforce protections, supporters argue these are not often enforced, and the ERA would bring them into full effect. With those issues in mind, Nevada became the 36th state to ratify the Equal Rights Amendment, and with that, a new host of questions came up. Was the deadline still in effect? And if it was it still constitutional? Associate Justice Ruth Bader Ginsburg, and a longtime supporter of the ERA, stated that there was a deadline and felt the effort must be restarted entirely, reinforcing arguments made by opponents of the ERA, including the Heritage Foundation and even the Department of Justice. However, some experts believe a deadline may not be constitutional whatsoever, looking at historical examples like the 29th Amendment. It was first suggested in 1792, and after 2 centuries, it was ratified in 1992. The court case used to suggest deadlines may not even have any relevance at all when examining the facts of the case. Dillon v. Gloss upheld a 7-year time limit for ratification of the 18th Amendment, but states had already ratified the amendment before the time limit, and that deadline was included in the amendment itself. Additionally, the legality of the rescission by states was called into question, leading some supporters to consider states' rescissions as null and void. Regardless of the legal challenges, activists press on. Illinois became the 37th state to ratify the ERA on May 30th, 2018. Virginia became the 38th state to ratify the amendment on January 15th, 2020, which reached the minimum number of states necessary to ratify the amendment. Despite this, even the most optimistic activists believe it could be at least 2 years before the future of the amendment is confirmed in court, and even if the amendment were to be adopted in the Constitution, it would be at least 2 years before it would take effect due to Article 3 of the amendment. At this time, no action has been taken to confirm the future of the ERA, leaving it in an unclear position.